Hi everyone, and welcome back to the North Carolina Redistricting Leadership Program with All on the Line. Today we are going to do a deep dive into the North Carolina redistricting lawsuits from the 1990s. So originally at the end of the previous class I had said we were going to talk about lawsuits from 2011 to 2018, and we will still do that. But there are a couple of really important cases in the 1990s that I didn't want us to miss. So making this lesson also a deep dive. All right, so North Carolina redistricting litigation in the 1990s. So the way we're going to walk through this is first we will talk about sort of generally what was going on in the 1990s. We will talk about the effect that the Gingles case had on litigation then, and sort of on the dynamics of redistricting then, because obviously we talked about it in a previous class. It was a really important case. We will go through two of the cases that were most impactful, Shaw versus Reno and Cromartie versus Hunt. And then at the end, we will try to tie up and sum up all the elements. All right. So what was going on in the 1990s? As you may know, redistricting litigation is really a North Carolina tradition. We've been doing it for a long time. We do it constantly. And it's been basically something that has happened every decade alongside the actual redrawing. So in the 60s, the cases were mostly focused on the disproportionate nature of the maps before the one person, one vote principle was sort of enacted or set as precedent, and how that disproportionality affected Black North Carolinians. In the 1980s, we saw Gingles versus Thornburg, which basically further defined the use of the Voting Rights Act in redistricting, and that was what our last lesson was about. Gingles, to sum up really briefly, mandated the creation of single-member majority-minority districts where certain conditions were met. And I just took this screenshot. I thought it was interesting. So from 1992 to 2019, we have had 7 different congressional district maps. And that's about 30 years, and in 30 years you would expect about 3. So clearly we do this a lot. All right, so there are echoes of what happened in the 1990s even today. The Gingles ruling really reshaped the gerrymandering sort of battlefield in ways that still have a huge impact. It set up dynamics between Republicans and Black and white Democrats that still exist. And these same dynamics will definitely be at play next year, and so it's important to be aware of them as we face another decade of fights, probably. Hopefully not, but probably. So, and here I've just put some pictures of some of the people who were involved in these cases in the 1990s and are still involved in redistricting today. Senator Dan Blue, he's the current Senate Minority Leader, and he was in the legislature. Back then, he was in leadership. Art Pope, who you probably have already heard a ton about, a huge Republican donor, was involved in these cases, currently being appointed to the UNC Board of Governors, an institution that I think he doesn't really like. And then Bill Barr, who was Attorney General at the time in the 90s and is also Attorney General now, which tells you a lot about what's going on in 2020. All right, the Gingles Effect. What kind of effect did Gingles have sort of on the landscape of redistricting? So the Gingles fight sort of set up some divisions that are still having an effect today. So at the time, many Black North Carolinians wanted to fight for these single-member districts, especially majority-minority districts, because the multi-member districts that were in place at the time diluted the Black vote and kept Black communities from electing the representatives of their choice. So at the time, Democrats were in a majority in the legislature. They were, of course, a majority of the congressional delegation. And because there were multi-member districts, especially in the legislature, Black voters were not able to elect Black candidates because their votes were overwhelmed by white voters. At the time, Republicans also favored these single-member majority-minority districts because, as an article written at the time said, packing Black people into a few districts means that the surrounding districts become wider, less democratic, and fertile soil for GOP candidates. So there was sort of this synergy where both many Black voters and Republicans saw single-member majority-minority districts as being something that was advantageous to them. The people who opposed this at the time in the legislature were white Democrats who held the majority and who had benefited from multi-member districts in terms of, having large representation for white Democrats. So after the Gingles case happened in 1986, redistricting litigation kind of exploded in the 90s, and there were a ton of different cases that set important U.S. Supreme Court precedents. And at the time, Democrats controlled the state legislature, and the majority of cases were brought by Republicans who were challenging the maps on the basis of racial gerrymandering. So, the 12th district. I'm sure most of you know about the 12th district. It may be the most famous gerrymandered district, certainly the most famous gerrymandered congressional district in American history. And it was the district that was the most often challenged during the 1990s cases. So, this district was drawn in 1992 when the original 1991 map had failed pre-clearance due to a lack of black representation. So the map that was drawn in 1991 had only one black majority district in it, that congressional map, and it failed pre-clearance, and the Department of Justice forced the legislature to redraw it. And the Democratic legislature's response was to draw this 12th district as the second black majority district. So I mentioned pre-clearance, and just to say what pre-clearance was, Voting Rights Act pre-clearance was a process by which certain jurisdictions that had had a history of suppressing black voters, like North Carolina, had to submit any new voting regulations or redistricting maps to the federal government for approval to make sure that they comply with the Voting Rights Act, sort of ahead of time. So before you would have to sue about it, the DOJ would get a chance to look at it and see whether or not they thought it complied with the Voting Rights Act. In 2013, we had this case called Shelby versus Holder, where basically Chief Justice John Roberts destroyed this provision of the Voting Rights Act, said that there was no racial discrimination happening regularly anymore in these jurisdictions, and so it was no longer needed. And the fact that this preclearance no longer exists has probably enabled most of the most egregious voter suppression measures we've seen in North Carolina, many of which has subsequently been overturned by the courts, but which made lots of people suffer and foreclosed their access to the vote while they were in place. Yeah, and here's me crying because I don't want to talk about it. So the 12th district was challenged multiple times throughout the 90s, primarily by Republicans who said that was an unconstitutional racial gerrymander. The most notable cases were Shaw versus Reno and Cromartie versus Hunt, which both resulted in redrawings of the 12th district in 1997 and 1998. As you can tell, strangely enough, when Republicans gained control of the North Carolina General Assembly in 2010, they largely kept the form of the 12th the same until they were forced to redraw it in 2016. So as you can see in the top left map here is the version of the 12th that was drawn in 1992, and then it went through a number of other versions due to a lot of litigation. But in the bottom right, you can see that is the version of the 12th that the Republican majority drew, and it doesn't look that different, so I don't know, weird. All right, so the first case we're going to talk about, Shaw versus Reno. So here's a quote from the majority opinion in that case that was written by Justice Sandra Day O'Connor. A reapportionment plan that includes in one district individuals who belong to the same race but who are otherwise widely separated by geographical and political boundaries and who may have little in common with one another, but the color of their skin bears an uncomfortable resemblance to political apartheid. So in this case, Shaw versus Reno, a group of North Carolina voters who were later joined by the state Republican Party challenged the 12th district on the basis that the Attorney General Bill Barr, at the time and now, I'm sorry, I keep saying it, but it's so weird, had created an unconstitutional racial quota when he forced the legislature to draw a second black majority district. So again, if you remember, what happened was the original map that was drawn only had one black majority district. It was rejected by Bill Barr. He ordered the legislature to draw another one, and 12th was the second black majority district we got. So these voters were saying that that was an invalid use of his power. All right. So in the opinion that came out of this case, a majority of the justice found that the district was so bizarre and so strange in shape that it was clear that it was solely based on race. And if something is solely based on race, then it should be subject to strict scrutiny to determine whether or not that use of race was narrowly tailored to serve a compelling government interest. The compelling government interest that it could be narrowly tailored to serve would be the representation of Black North Carolinians under the terms of the Voting Rights Act. So strict scrutiny was required as to whether or not it was really necessary to use race in this extensive way to meet the requirements of the Voting Rights Act. The case was ultimately sent back to a lower court so that it could be evaluated in this way, and the legislature was formed to modify the district in 1997. So on the previous slide, you saw the district as it looked in 1992. This is the version of the district that we get out of the Shaw versus Reno case in 1997. This here has been significantly shortened and sort of made wider in some places. Right. So the dissenting justices also made a number of important points, though, in this case. So first, they said the 12th district had been challenged by white voters, not by Black voters. The 12th district, as drawn, had enabled Black North Carolinians to elect the first Black member of Congress from the state since the end of Reconstruction. So in almost 100 years, for the first time, this district allowed Black voters to elect a Black representative to Congress. And Justice Stevens, in particular, felt that using the Equal Protection Clause of the 14th Amendment, so this is an amendment that was created to protect the rights of Black Americans, so using that clause to subject a district that advantaged Black voters to stricter scrutiny than districts that advantaged non-racial groups was perverse. So basically using the Equal Protection Clause to say we are going to examine this district that advantages Black voters really strictly in the way we wouldn't examine a district that, say, advantages a particular party, that gets stricter scrutiny. So Justice Stevens believed that that was sort of a perversion of the 14th Amendment. So clearly this is really complicated. It's a case where it's easy to see that both the majority and the dissenters have some good points. So intentionally packing Black voters to create a majority Black district that is a really bizarre shape that doesn't really clearly relate to any distinct political community, neighborhood, place that people actually live, that kind of follows a highway, and that's the most contiguous thing about it, that seems inherently problematic. However, the district did allow Black voters to elect a Black congressional representative for the first time in almost 100 years. And the people who actually objected to the district enough to sue over it were white voters in the Republican Party, not Black voters. So clearly there are a lot of complicated factors at play here. All right, so Cromartie versus Hunt. This is the other significant case of the 1990s that we're going to talk about. So again, this was another suit about the 12th district. And this was a suit against the version that was drawn as a result of Shaw versus Reno in 1997. So this version was challenged in court as a racial gerrymander, despite the fact that the new district was 51.6% white. A three-judge panel basically granted summary judgment, so they said that they felt that the evidence was so strong that it was a racial gerrymander in this case that they were going to go ahead and order the legislature to redraw the map without a full trial. And so the legislature redrew that 12th district again, and that map was used for the 1998 elections while the case was still on appeal to the Supreme Court. So here you can see on the left, this is the 1997 version that was drawn after Shaw versus Reno, and then you get, on the right is the 1998 version that they drew in response to this federal court ruling. So once that 12th district goes to the Supreme Court, something sort of interesting happens. The lower court summary judgment decision was overturned because the legislature had submitted evidence that the reason they drew the district this way was for partisan reasons, not for racial reasons. So the legislature basically said, we drew this district because we were trying to preserve the partisan balance of our congressional delegation, and the Democratic voters that are in this district, there's a high proportion of Black voters because those just happen to be the Democratic voters in this district. And so Justice Clarence Thomas was the one who wrote this opinion, who overturned the summary judgment, because he said that that the court just hadn't examined this evidence that it could have been drawn for partisan reasons. So the argument that was made here that the Democratic voters in the district hadn't been targeted for their race, but they just happened to be Black, really brings out one of the core facts about gerrymandering in North Carolina. And that is, because such a high proportion of the Black population in this state identifies as and consistently votes for Democrats, it's often really hard to differentiate racial and partisan gerrymandering. A lot of the time, you are just relying on the legislators' representations of what they're telling you that they're doing. So, like with the Supreme Court, the legislature had submitted evidence that they were just doing this for partisan reasons, but it's really difficult to tell because there is such a huge overlap between partisan identification and race in North Carolina. And this case especially brought that out, and it made clear that in the future, the Supreme Court, while it was willing to strike down things that it thought were obvious racial gerrymanders, it was going to be a lot more reluctant to address any kind of partisan gerrymandering. And so, sort of to illustrate this point, I pulled this picture from NPR. That is, on the left, you have sort of the vote share of Obama in 2012 across the state, and on the right you have the percentage of Black voting age population across the state. And so you can see sort of the correlation there, and why racial gerrymandering and partisan gerrymandering are really, really difficult to disentangle in the state. All right, so let's bring this all together. What are the key takeaways? So, first of all, most important thing to remember, and I'm sure this is something you all already know really well, Republicans and Democrats both gerrymander for political advantage. It's not a matter of party in the sense that both of them are equally capable of being politically interested in their own advantage and drawing the maps to support that. So it's just something to be aware of. 2, creating districts with very high percentages of Black voters can make it easier for Black representatives to be elected. So that's true. The districts we have that have high percentages of Black voters often are the places that elect Black representatives. 3, these same majority Black districts are often favored by Republicans because it gives them an advantage in surrounding districts by packing Black Democrats. So if you recall in 2011, or when we talked about the Gingles case, we talked about those quote-unquote VRA districts that were drawn in 2011 without regard for the Gingles factors, basically just drawn to pack as many Black voters into as few districts as possible. And the justification there on the part of the legislature was saying that, okay, well, we're doing this to ensure Black representation, but it also played into their ability to partisan gerrymander for Republicans. Now, what I will say is you may say, okay, well, why were they challenging the 12th district then as a racial gerrymander? I mean, shouldn't that advantage them? Well, and I think in the greater scheme of things, the issue is that it actually did reduce competition for them. So in 1992, under the map with the original 12th district, we see Democrats are holding 8 of the 12 seats in our congressional delegation under that, like, very, the first version of the 12th district. And then after the 1997 elections, in that redrawn version, Republicans are holding 7 of the 12 congressional seats. So clearly there was some impact there on the proportion that each party ended up having in North Carolina's congressional delegation after that redraw. But in general, like I said, with the 2011 quote-unquote VRA districts, often packing Black voters creates opportunities for Republican partisan advantage. So, 4, racial and partisan gerrymandering are very difficult to differentiate in North Carolina. It's just a fact. I mean, it's just true that most Black voters identify party-wise as Democrats and vote for Democrats consistently. And that means that when you use the excuse of saying, okay, well, it's not racial gerrymandering, it's just partisan gerrymandering, and the people in the district just happen to be majority Black, it's very hard to tell whether or not that's happening, and courts often default to taking the legislature's word for it because it is so difficult to untangle. 5th thing to remember is just that redistricting is complicated. There are a lot of different incentives here. There are people who want to look out for their own advantage. There are parties who are looking out for their partisan advantage. There are obviously, lots of dynamics in how different racial groups, especially Black North Carolinians, are represented that interplay with all of those things. Basically, there are tons of different interests at play, and it's not a simple matter of just whether Republicans or Democrats are gerrymandering for their advantage. There are lots of different groups that have lots of different interests. And so it's something to keep in mind next year during the 2021 redistricting. It's going to be complicated. And there are going to be times where you don't understand why something is being drawn or why a district is being created in a certain way. And honestly, that's usually because you don't understand or don't know exactly whose interests are at play. So, something to keep your eye out for. All right, so that is the end of the lesson for today. Again, next lesson is going to be that lesson on the 2011 to 2018 cases. This was sort of a little detour into something I felt was really important because I feel like a lot of these dynamics really do show up and will show up next year. And thanks for being here. Again, if you have any questions, please feel free to email me, and I will hopefully see you all again soon.